tarde a todos. Essa é uma sessão especial do CBMA em associação com o Instituto dos Advogados Brasileiros. As duas instituições têm um acordo de cooperação e nessa tarde e noite nós temos a possibilidade de ouvir o Dr. Bruce Edwards, que foi advogado militante durante vários anos e de que foi no curso da sua prática da advocacia, tomou conhecimento com o Instituto da Mediação e, a partir daí, dedicou o seu tempo e a maior parte da sua atividade profissional a essa atividade que, no Brasil, está se tornando cada vez mais admitida como forma de solução de disputas que são resolvidas fora das barras do tribunal. E eu tenho ao meu lado direito a Mariana Freitas de Souza, que é vice-presidente de mediação do CBMA e que está aqui para funcionar na qualidade de também debatedora, na medida em que Bruce Edwards, depois da sua fala, abrirá a palavra para todos os integrantes dessa audiência e também para que eu e a Mariana, possamos dirigir algumas indagações e desenvolver temas que tenham sido abordados. Mr. Edwards, it's a real pleasure to have you in our house. And just for your information, this Institute of Brazilian Lawyers, Instituto dos Advogados Brasileiros, is the oldest institution dealing with legal matters in this country. It was founded in 1843, so very soon it will be 150 years of very active presence in the legal world in Brazil. And I'm going to give the word to Mariana Freitas de Souza, who will make a more detailed introduction of yourself. Let me say that's a great pleasure. We are very honored that you gave us the opportunity to hear your experience as a lawyer, how a lawyer can take the best advantage of mediation as a means of solving disputes. Mariana.
Obrigada, Sérgio. Boa noite a todos. Obrigada pela presença. Queria primeiramente agradecer ao IAB pela parceria e pelo apoio, não só nesse evento, mas em tantos que a gente tem conseguido fazer em conjunto, sempre visando a promoção da mediação e das formas alternativas de resolução de conflito em geral. O Bruce Edwards é um amigo pessoal e é uma referência em mediação nos Estados Unidos. Ele é um dos fundadores do GEMS, que é hoje o maior provedor de serviços de mediação e arbitragem do mundo. Eles atuam mais ou menos em 12 mil casos por ano, então esse número é sempre impressionante. E eles também se impressionam quando a gente diz que tem 100 milhões de processos judiciais parados no judiciário brasileiro. Então, os números impressionam de parte a parte. E o Bruce nos deu a grande honra e o prazer de vir ao Brasil para o Congresso do CBMA, que acontece essa semana, quinta e sexta-feira, na Firjan, e também nos deu a possibilidade de vir dar essa palestra aqui no IAB, que foi pensada para os advogados, foi pensada realmente para trazer mais informação, mais conhecimento aos advogados. Essa palestra está sendo transmitida pelo site do IAB, então pessoas também de fora do Rio têm a possibilidade de assistir, conhecer um pouco mais sobre esse instituto e, principalmente, entender como o advogado funciona no mundo da mediação, como o advogado pode entrar nesse meio, fazer disso realmente um mercado para ele, seja como mediador, seja como advogado de uma das partes numa mediação. Então, vou passar a palavra para o Bruce, que vai poder realmente nos brindar aí com toda a sua experiência de 30 anos como mediador nos Estados Unidos, na Califórnia.
Antes de passar a palavra, Mariana, eu gostaria de registrar um pedido do presidente Tessores e Silva, que ele gostaria de estar presente, mas não teve essa possibilidade, já que está participando de um seminário em Brasília sobre a reforma trabalhista e o sistema internacional de proteção dos direitos humanos. Então, essa é o que impediu de ele estar presente. Let me say, Mr. Edwards, that I have a word from the president. Eu quero falar em inglês. Okay. Let me say that I have a word from the president of this institution, and he is very sorry, and because he's in Brasilia today, attending a special seminar on labor matters, and he's flying tomorrow to Belém for another presentation at a seminar of criminal lawyers. So as you can see, our president is a jack of all trades. Mr. Edward, I would ask you if you would like to have the podium to make a presentation to this nice audience.
Okay. Thank you for the kind invitation to come address you this evening. Thank you for the very nice introduction as well. It's really a pleasure to be here in Brazil. It's my first opportunity to visit your country and certainly to speak to brethren and sistren in the mediation community. How many of you, I assume, are lawyers? Most of the audience is lawyers? You can raise your hand. Any of you then mediators, practicing mediators as well? Okay. How many of you have been through mediation training of one sort or another? Good. So I know who the audience is. My topic tonight is really to discuss mediation from the perspective of what's in it from the lawyer's perspective. Why do why do attorneys want to get behind the mediation movement? What's in it for them? And while I have a number of other topics that I can discuss after the program or in questions, this is really the focus of my comments over the next 45 minutes or so. As difficult as it is for me to talk about myself, I do think a little background is helpful and important, primarily so you can see a vision of what's possible. I don't pretend for a moment that everything that I say to you is necessarily appropriate or even easy to adopt in your culture. As I travel around the world and I talk to mediators and attorneys, I say, take the best lessons that we have to offer, apply those within your culture and your legal community, and make work for you what's possible. The last thing any Americans should be doing these days is traveling around the world telling people we know how to do things, okay? So my experience, I began with the thought that I would someday go to law school, and I did. I went to college, I went to law school, I became the youngest partner in a 50-person law firm in San Francisco after about 5 years, and at one level, at least in my parents' vision, had sort of reached the pinnacle of my career. Yet I was not satisfied. And I was not satisfied because the way that I saw my clients responding to our traditional litigation system was less than satisfying for them. And fortunately for me, my background was in psychology from an education standpoint. And so it got me thinking about this process of litigation that most of us are trained in law school, that most of us bring to bear as young lawyers. It's certainly what I was coached in as a young lawyer in a litigation firm. Yet it really didn't provide the type of answers or the type of solution that my clients, for the most part, responded to. And so I started thinking about what was it that was missing. And without going into much detail, what was really missing was the human element, being able to address people's interests and concerns in a way that was respectful of the human condition, dealing with emotions, dealing with interests and needs. And so we began to think about developing another process, not in substitution for the litigation process, but something that was an adjunct to the litigation process that we could offer our clients. And from there, I began developing this mediation process. I then began one of the first mediation companies in the United States, perhaps the first that was a national company made up exclusively of lawyers. When I left the law firm to start this business of mediation, my parents thought I had failed in life. After all, what was mediation? Why would you walk away from this successful legal career and start this process that nobody's ever heard of? And there was a small part of me that thought I was crazy too. Fortunately, I was young enough, though, to do crazy things. And from there, we grew this company to a national company of about 12 offices around the country, exclusively attorney mediators, some arbitration, but exclusively dispute resolution. And now, 30 years later, we're the largest company in the United States, by far. As Mariana has suggested, we did about 12,000 cases last year. Since the focus of the conversation is on what's in this for lawyers, why should lawyers get behind this process? It's important to start the conversation by letting people know that what we do and what we have to offer should not be viewed as a threat to lawyers or their livelihood. And there are many countries that I get the privilege of speaking in where there's a storied history to the legal profession, just as in Brazil. Look around this room is all one needs to do to appreciate the rich history of the legal tradition in Brazil. And mediation should not be viewed as a threat to that tradition. In the United States, our legal system is only about 250 years old. If you go back to England, which is the roots of our system, you might say it's 400 years old. But in 25 years, we've been able to fundamentally change the legal system by the introduction of mediation and, to some degree, the pursuit of arbitration and dispute resolution generally. And yet, when I say that that has not threatened the legal system, and lawyers in particular, let me give you some numbers. Up until about 3 years ago, I was the chairman of the board of our company, and in addition to mediating every day, my job was to help run the company. And every year in the United States, there's a publication that ranks the gross revenue from the top 200 or 300 law firms in the United States. That year, I think our company did about $150 million in revenue mediating and arbitrating disputes. If you put us, or if we were a law firm and you were to put us on this ranking of law firms in the United States, at that point, I think we would have been about number 195. Okay? We're not in danger of putting law firms out of business. We're not in danger of putting lawyers out of business or threatening their livelihood. What we are in business of is giving people tools to assist their clients in a more fundamental way that addresses their interests and treats them in a very human and respectful way. Since most of you have been through mediation training before, I will assume there's a common understanding of what mediation means to you. To me, fundamentally, mediation involves two key concepts. One, it's a process that is interest-based. It means that we're trying to identify what the client's needs and interests, psychological desires are at a fundamental level so those can be addressed. Secondarily, it is based on parties' right of self-determination. I mean, how many people in the audience prefer to be told what to do as opposed to participate in making those decisions that fundamentally affect themselves and their family? I submit very few of you. For the most part, the beauty of this process is that it involves those people who are involved in conflict. Without going too far afield for tonight's conversation, it helps them work through psychological processes in a way that is fundamentally helpful, if not transformative in their lives. And all of that can be done against a backdrop of rules and facts and laws that embraces the lawyer's role in that conversation. Okay? So what we've done in 30 years is develop this culture of mediation. And why have we been so successful? How has this process taken root in the last 25 years in an institution that's almost 250 years old? Well, there's several reasons. As I said already, I think primarily because it fundamentally addresses people who are in conflict and what they need when they're in conflict. The ability to communicate with each other, the ability to be heard when they're in conflict, and the ability to fashion decisions that work for themselves. So this process really drives itself. But more than that, there have been other supportive institutions and occurrences over the last 25 years that have gotten us to this point. About 10 years into our process of mediation and going out and trying to educate the community, the legal community, consumers, corporate lawyers, insurance companies, about 10 years into that process, the courts recognized that there was value to this as well, significant value. Our courts at the time were crowded. Litigation is expensive. The pre-litigation discovery process is expensive and cumbersome and time-consuming. And it resonated with the courts that here's a process that was eminently successful. Statistics aside, whether you settle 60% or 70% or 90% of your cases, it doesn't matter. If you went to the court system and you said, on any given day that we pull the parties together and put them in a room with a facilitated conversation by a mediator, there's a greater than likely chance that case can resolve and get off your crowded docket. Guess what? Courts embraced it like it was sliced bread, like it was the next best thing invented. And so within that time period, courts started requiring mediation, just as they do now in Brazil with your court annex programs. And so today in the United States, certainly in federal courts, in most state courts, you will not be able to get access to a courtroom, a judge or jury. They won't devote court time to you until you've been through a mediation process. Whether it's an annexed process with voluntary mediators or it's a commercial process with a company like mine, you must be able to check the box and say you've tried the mediation process first. And that gave us a very big jump start getting that kind of blessing from the court system. Over time, clients, particularly repetitive users of litigation services, became very big supporters of mediation. If you were chief legal counsel for a large corporation, if you were an insurance adjuster with 200 claims on your desk that needed to be resolved, if you were an attorney who got paid on the day that a case settled, these people were all ripe for discussions about better ways of doing business. They were tired of the traditional time delayed and expense of litigation, and they not only embraced mediation, but they became proactive in trying to require their lawyers to attend to mediation, to suggest it when lawsuits got filed, and sometimes even before. So over the last 25 years, we've reached out to all of these different communities, all these different stakeholders, and over time, I should accent over time, for those of you who might feel discouraged that in year 5 or year 10, you're not where you want to be. I get that. I'm not where I want us to be either. But we've made significant strides, and at this pace, I like the trajectory. So I hope, standing up here in front of you, if I do nothing more tonight than send you a signal of what's possible, that I sort of light that spark of inspiration that commercial mediation is alive and well, not just in the United States, but developing in other countries. I was in Berlin, Germany last weekend talking to the German Bar Association about how to use mediation in their complex construction cases. Earlier this year, I've been to India teaching mediators. I was in Rwanda in January, working with the federal government to put mediation into the law so that it becomes mandatory in their civil justice system. So all around the world, there are these efforts to try and incorporate the best of the mediation world within local communities, cultures, and legal systems to try and really help people gain access to justice. I came here tonight, though, really with one purpose, and that was to help you appreciate, from the lawyer's perspective, why do you want to get behind this concept, the what's in it for me kind of self-interest. We'll set aside for a moment that there are greater considerations than our own individual needs. I get that. I talk about those most weeks. The concepts of access to justice in communities such as yours, where there's a backlog of cases that numbers in the millions. But from an individual practitioner's perspective, what is it about mediation? Why is it that you want to embrace it? Why do you want to get behind it? I'll give you some examples. In the early days of my experience, I would go out to law firms and I would talk to whoever would listen to me about the benefits of mediation. As always, in any kind of a sales role, you get different reactions. Those people who have an obvious willingness to embrace the message, others who slam the door in your face, Some who will politely listen to you, but you know that they're not going to adopt what you have to say. Some who are very blatant about it. At the time, I was a 30-something, year-old lawyer. I had a full head of hair, but I didn't have any, esteem in the legal community. And so I would have older lawyers say, Bruce, it sounds like it's a good process. It might work for her, it might work for him, but it's not really for me. I'm a litigator. I take my cases to court. I said, well, thank you, I get that. And I would leave, and I would go on, and I would try to find a more receptive audience. But I had a term that I didn't use publicly, but I used it in my own mind for those people, and I called them dinosaurs. Because, as we know, dinosaurs are on an evolutionary trajectory that isn't necessarily the most adaptive. And those that did adapt survived. Interestingly, I can still remember some of those senior partners in firms. Several years later, a woman who ran litigation for her corporation and became a real believer in mediation for what we call a Fortune 500, one of the larger corporations in the United States, called her lawyer, her outside counsel, and said, I understand you're not using mediation. Why? I've had a lot of success with it. And he attempted to convince her that it wasn't the right thing for her cases. And the next thing that happened was she politely disengaged him, told him to pack up the 200 files that he had in his office with all his partners and associates working on their defense, and she was transferring that work to another law firm that did believe in this new idea of mediation, as one example. I will add, parenthetically, that about 15 years later, as chairman of my company, I often get resumes from those people who want to become mediators. Lo and behold, there was a resume from this senior partner who is now being asked to retire from his law firm at the mandatory age of 65, and lo and behold, he had seen the light, the wisdom, and he wanted to become a mediator himself and was applying for our company to hire him in that capacity. So people evolve over time. Those that don't, obviously, don't prosper. Those that do kind of get in front of the process and adapt to it. With regard to why, as attorneys, we want to embrace this process, think about it for a moment. Think about the reasons that brought you to this profession. If you're like most of the people that I have the pleasure of speaking with, you came to the profession because fundamentally you have an interest in helping others. You have an interest in applying the law for the betterment of your client. Yes, in a partisanship environment, I understand, but really to try and help find solutions. That's the core of the legal profession. It really represents the best of our legal tradition in the United States, certainly. And if you go back 100 years, there's fabulous quotes by Abraham Lincoln and other famous lawyers from our American tradition about the importance of trying to help your clients avoid conflict, look for solutions, the very kind of language that now we talk about in the mediation community. So in many respects, it's a return to that fundamental motivation for why we became lawyers. And then from a practical standpoint, if you're in the mediation process, what does it look like? You're meeting with your valued clients face-to-face to prepare them for this process. You're going to this mediation with them, oftentimes spending half a day or a day at their side, getting a chance to know each other better, to better understand the needs and commitments. So it really brings you closer to your clients as well. Another reason why those sophisticated mediation advocates really appreciate the mediation process. Let's talk for a moment about the most difficult conversation that confronts us as lawyers. Economically, how does it impact us? And really, what is there in this process that makes sense for who we are, how we bill our clients, and what does that mean to our economic future? And in polite society, we often don't talk about these topics. I'll start with that acknowledgement. And when I go to Mexico City and I have a group of lawyers say, Mr. Edwards, this all sounds well and good, but I bill by the hour, and if you're settling cases early on, how am I going to feed my family? I get that understanding, okay? So it may be that in certain cultures there is the need to re-examine and reorient billing structures by lawyers so that they in fact contemplate the possibility of early settlement. They in fact reward the possibility of early settlement. In the United States, for example, there's a billing system called contingency fees. And so these are lawyers who essentially get paid a portion of the amount that is returned in the litigation. And that happens when the case resolves or goes through trial. Guess what? That was our most receptive audience in the early days, because they looked at me and said, wait a minute, Bruce, let me see if I understand what you're saying. I can pick the day where I've got a chance of settling this case and getting paid, and my client is going to be happier in that process than going to trial? Why wouldn't I try that? And that, in fact, was an introduction to the people who had a billing format that was on a contingency basis. But it may be that there are other types of billing processes where retainers can be taken from clients, and whether the retainer covers the first year or two of legal representation, but lawyers get to keep the full retainer even if the case resolves sooner within that time frame. There's lots of ways to consider how to adapt a billing structure so that it does, in fact, favor representing clients in a mediation process and helping clients get to an earlier resolution and an appropriate resolution. Those are things that obviously would be appropriate conversations to have amongst yourselves as you contemplate how to reinvent yourselves around this mediation process, and in turn kind of reinvent your legal community. And I say it that way because things are changing. You know that. I'm not telling you anything new. I've got 3 kids in college. I mean, not only can I not finish a complete sentence, but I barely get them to look up from their electronic devices at me at the dinner table. And lo and behold, we're going to seminars and we're learning all about these things called the online dispute resolution. Right? So those of you who have been to those seminars with Colin Rule in the United States, you know that eBay conducted over 60 million disputes online last year. In San Francisco, where I live, just north of Silicon Valley, one of our early and most receptive audiences were those people in the high-tech community. They said the current litigation environment as we know it doesn't serve us. It doesn't serve our needs. The technology will be so far behind us in 3 years, by the time this case gets to trial, we need another way. And we would say there is another way. Get together, let's talk about it, let's see if we can come to resolution that makes sense for both businesses in this trade dispute, in this intellectual property dispute, and both get on with what you do best, inventing new technology, developing new programs, and moving forward. So this whole concept of society in rapid change, I can give you other examples. The court system in Britain and its provinces in Canada, the small claims courts that have a jurisdiction of less than 5,000 euros or pounds or dollars, I forget the measurement, they've closed those courthouses entirely. All of those disputes are now handled online. Okay? If you go to the Netherlands, or if you're in the Netherlands, they've got an online dispute resolution program, 20 steps that have been put together by lawyers, psychologists, family counselors, and judges. And so the lawyer's role in that context is further refined as well. These are all just sort of small examples of things that are happening all around the world. And so it's incumbent on us as lawyers to recognize that change, to get out ahead of it for the benefit of our clients, if not for ourselves, and try and be part of the most sort of positive aspect of that change. There will always be room for lawyers in solving problems. Don't doubt that for a moment. The question is going to be, what does that process of resolution look like, and what's your role? So I want to shift gears for just a moment and talk about your role as an attorney in the mediation process, what we describe as mediation advocacy. Okay? And I distinguish that from being a litigator, even though in the United States, as far along as we are in the process of alternative dispute resolution, you go to any major law school in the United States, and there probably is a class now on mediation and arbitration. But what's really missing is any kind of class on how, as a lawyer, you behave in mediation. I talk to young lawyers all the time, and I say, you know what? Federal court cases that go to trial are down about 30% around the United States. State court, still plenty of opportunities, but complex commercial litigation, not so much for young lawyers to get into the courtroom. We have societies, organizations such as this, where you have to have 30 or 40 or 50 trials to be admitted into these bodies of experienced lawyers. What they're finding? They can't get enough qualified candidates because not enough people have that kind of trial experience. So I say to young lawyers, I say, you went to law school maybe because you want to be a litigator. You certainly want to be an advocate. Guess what? Your opportunities to be an advocate in mediation and arbitration will far surpass your opportunities to be an advocate in the trial setting. And so you need to distinguish for yourself what types of skills are going to be necessary and beneficial to your client for participation in mediation versus what you may have learned in law school and in your early years of being a lawyer and how to behave in trial. Okay? I was only taught in law school and in my law firm, this is how you become a better trial lawyer. Nothing was said about resolving cases. And to this day, what's amazing still in the United States, there are all these wonderful seminars about how you take a deposition, how you give an opening statement to a jury or a judge, how do you give the best, most persuasive closing, knowing full well that the opportunity young lawyers have to do those things, very, very limited. Yet, when people are going to be in mediation, I mediate every day of the week. I've mediated for 30 years, almost every day of the week. I see lawyers who have come through thousands of mediations, and yet very little time is spent educating those lawyers on how to advise their clients or to behave in the mediation context. And so if there's a next evolution within the United States and hopefully within other countries, it's going to be geared toward further educating those lawyers who want to better understand the unique skills that they will need to be an effective advocate in mediation. What are those skills? I mean, talk about personality traits for a moment. Talk about those lawyers that are creative, those lawyers that are empathetic, those lawyers who are good listeners, those lawyers who can read the social cues in a group in the room. I mean, I'll give you some examples. Social cues. I had a lawyer once, we had a group of parties around the table, and the plaintiffs prepared a very persuasive case about the impact of the brain injury that their client had received as part of this negligence on the part of the defendant. And the defense counsel asked for a moment if we could take a recess, and he stepped out into the hallway with his client for 5 minutes, came back in the room, and literally tore up his sheet of paper and said, "Mr. Edwards, I want to speak to the other side with an open heart." He said, "I appreciate that we're here today with differences of opinion. I came prepared to discuss those from a legal perspective, even a factual perspective, and I will. But more than anything, I just want everybody to know on that side of the table that we're here today to try and find a common good, a common outcome for the benefit of your client, consistent with how we view this case. But I'm going to set aside a lot of the arguments that I had prepared coming today because I think they would be more disruptive than they would be helpful. And we'll talk with the mediator privately about how we can move forward together." Okay? So somebody who read the crowd very well that morning, somebody who could have taken it in a completely different direction that might have jeopardized their chances of success, but just one example of somebody that sort of got it and was able to move the process forward by reading the social cues. So skill sets, the threads that run through those most successful mediation advocates are threads of empathy, are threads of creativity, of trustworthiness. Those are the things that we see from the mediation end of the table time and again for those people that are most effective on behalf of their clients. What else do skilled advocates do? And I apologize to some degree for sort of moving quickly through this discussion. Understand that if I were to do this right, this could be a 2-day course or a 3-day course on effectively representing your clients in mediation. So really, I'm just trying to give you a little flavor of what's out there. Certainly, you can ask questions and follow up in a little while. But as much as anything, I want you to appreciate that it's a different skill set because it's a different environment, because it's a different focus than it is if going into the courtroom to try and advance your client's cause. So what are the other aspects of being an effective advocate in mediation as a lawyer that you want to have in mind and contemplate? Obviously, it starts from the very beginning. It starts with an awareness and understanding of the mediation process itself. being able to inform your client of all of the different tools that are available to you as a lawyer that will help them depending on their needs. It extends into working with a mediator that you've chosen for the right reasons. Within my company, 70% of my partners are retired judges. We have people who come in because they want to have a word of wisdom from the Chief Justice of the Supreme Court, who's now retired. Or they might come in and choose an attorney mediator who's female because they want that particular profile, or other various demographics. But that lawyer knows that different mediators have different styles, and they try and blend those choices with the right mediator for their client. Participating in the process design itself in advance of the mediation is something that I see experienced mediation advocates do very effectively. And I recently heard a story of one of my partners who designed a process where the parties came together in mediation initially, but the concept was that if that didn't work, they were going to separate and put on a very brief informal presentation of the evidence to the two decision makers on each side, and then come back together in a mediation environment. Just one example of creative thinking, of engaging and designing a process that met the needs of their clients in contrast to the 2 or 3 year path of litigation that they were on. So there's a whole field of things that competent mediation advocates think about and accomplish before they ever set foot in the mediation room. Once they come into my office that day, it's a different world. Hopefully they prepared their client, so the client knows to what extent he or she will be participating. They work closely with the mediator to read the room, as I've said earlier, to gauge an opening presentation that meets the needs of the audience as well as their clients. They learn a lot about how to be both a forceful advocate, but not to the point of contentiousness where it becomes disruptive to the process or otherwise counterproductive. And not everybody gets it right. I see lots of examples of lawyers behaving badly. Okay? Just this last week, I had a woman from India who was part of our international fellowship program. For her, it was a great day. She shadows mediators as part of our program, where they get to see how different mediators proceed in the mediation process. And what she got to see the day that she was with me was she got to see two lawyers behaving badly, not advancing the process productively for their clients, instead calling each other names, raising their voices, doing things that I won't even describe, but it left me feeling more like a kindergarten teacher than a mediator that day. I'll just leave it at that. So once you come into the mediation itself, being prepared to negotiate in a way that's effective for your clients and persuasive to the other side is a skill in and of itself. And there's an awful lot that's been written around the negotiation process. There's an awful lot of lessons to be learned about how, as advocates, you can be effective negotiators, taking advantage of your skills, your gender, your cultural background, your emotions, et cetera, et cetera, et cetera. But learning those things and being able to apply them meaningfully and productively for your clients is a necessary skill, and one that they don't teach generally in law school or even in law firms. Ultimately, if you're fortunate enough to get to a agreement in mediation, good mediation advocates know that the importance of trying to get the terms of those settlements solidified before the parties leave the building and maybe have a change of thought or opinion. The best advocates often come prepared with settlement agreements not yet filled out that can become the basis for a framework of discussion before you even get to a final handshake agreement, where people have something that is then can be put on paper. Good advocates know all of the laws relative to enforcing settlement agreements and can anticipate those. So just this past week, I was mediating a case where the parties resolved the case, and we called up the court and said, we would like to come over with all of these 20 parties and put this settlement on the record before the sun sets on this agreement. And the judge was kind enough to realize that he didn't want to have a 3-month trial, and he said, fine, my trial today is finished at 3 o'clock. Please come over. We'll put all of the terms on the record so it's judicially enforceable agreement. the sophisticated advocates in the room had suggested that. I thought it was a brilliant idea, and that's how we got that case from a handshake resolution to a formal commitment that probably saved several months of back and forth lawyering over a final settlement agreement. So just another example of what successful mediation advocates should be thinking about and can be doing as they both prepare to represent their clients in mediation and work through the different stages of the mediation process. So there's a lot that is going on in this world of mediation. A lot of different countries are attempting to try and incorporate the best ideas of what our experience has been in commercial mediation in the United States. Courts are now adopting mediation around the world in many countries. We're starting to see mediation laws, some better considered than others, but at least legislative bodies that are trying to promote mediation as well. And in many of these communities, as I said before, it becomes an access to justice issue for many people. If you're in a country, and you know much better than I do, but how long clients have to wait to get their matters heard by a court, how efficient or inefficient a process is, it all speaks to your client's satisfaction. And this goes back to the root of what it is that we're trying to do. We're a service provider as lawyers. We're trying to provide legal services to our clients to the best of our ability. And we're often frustrated by the environment that we're in, whether that environment is a cultural environment that disfavors settlement, or we're in an environment of courts that really is slow and pedantic and expensive. And what mediation does is it offers us a tool to be able to help our clients get their needs addressed and participate in those decisions that are fundamental to their lives going forward. That's the beauty, that's the value of mediation process itself. So what I'd like to do is really reserve enough time for us to really have a discussion to find out what's on your minds, because you're the ones with the feet on the ground in this community. I'm here really to be of service to you and try and help you understand how to move forward in developing and furthering a mediation community in Brazil, given all of the challenges that you have. And I'll start by acknowledging that you're further along than many countries that I have the pleasure of visiting, so take some pride and satisfaction in understanding that. But there still is a long way to go for all of us. We're here collectively to try and share thoughts and ideas on what we can learn from each other. So don't hesitate to share ideas with me that I can take back, not just to the United States, but other countries that I get to visit as well. But I appreciate your attention to these comments. I apologize to my translators for going a little quickly, and that's my nature. But thank you for keeping up. Anyway, thank you very much. I appreciate your attention. So there's no question that's off limits. You can ask me about the business of mediation, the business of lawyering. You could ask me about what's happening, in other cultures or communities. If I can't answer the question, I'll tell you that. But otherwise, I would like to hear what's on your mind after a busy day at work and trying to understand and appreciate where you are in this effort toward advancing mediation. I better.
Bom, boa tarde, professor. Muito obrigada pelas suas palavras, pelos ensinamentos. Eu queria lhe perguntar o seguinte. No Brasil, embora a gente tenha iniciativas em mediação há mais de 20 anos, a mediação ainda não está incorporada à cultura. E a gente tem, para a comunidade jurídica, o desafio de acolher essa nova proposta, esse novo caminho de resolução de conflitos. Em paralelo, eu tenho a sensação de que os mediadores, em geral, costumam acreditar que o advogado atrapalha e não ajuda. A minha pergunta para o senhor será que a responsabilidade, por ter uma postura condizente com a mediação é só do advogado? O advogado deve chegar na mediação já conhecendo o seu papel, ou será que o mediador também deve contribuir para essa ambientação acontecer de forma favorável? Muito obrigada.
for the thoughtful question. The direct answer is that it's necessary and appropriate for the mediator to be coaching the parties along the way. I start that process by having conference calls with the lawyers and clients before the mediation itself to help not just talk about the dynamics of the mediation, but even in my tone and demeanor, set the expectation for what I'm hoping to achieve in that mediation process. A sense of conciliation, a sense of respect, yes, within the context of forceful and appropriate advocacy, but in the process itself, helping channel people's behavior, which at times sometimes can include separating the parties or other behavior modification techniques that are somewhat nuanced but are guided towards making the process itself productive. So yes, as a mediator, I take on that responsibility very seriously. It's a core of what I do. There's another part of your question, though, that I would like to address even to the extent I understood the question or not. And it has to do with both a micro-analysis and a macro-analysis. The micro-analysis is we're looking at the legal community with blinders. What can we do to change the legal community? And to that extent, sometimes lawyers are viewed as a potential impediment to us making strides within that culture. I get that. And that is part of what we need to address. Don't lose sight of the fact that there is a macro picture out there as well. And that means there should be, we all must look for opportunities to advance these skills, these mediation competencies in other environments. So for example, this gentleman and I were talking before the mediation about using mediation in a medical context. And so for several years I've been teaching at Stanford University Hospital, not lawyers, not risk managers, but we've been teaching the physicians, we've been teaching the nursing staff, we've been teaching all the executive office staff, CEOs, CFOs, etc. Mediation skills so that they can better their own lives, so that they can interact within their departments and their work environments more efficiently, more favorably, reducing conflict when it occurs, ultimately in the environment between patients and staff. But in all of those environments that aren't involving a lawyer, how can we get them to be more appreciative of mediation as a vehicle for dispute resolution? And so I won't rest, God willing, until there are mediation courses in business schools, in medical schools, in engineering schools. Already in the United States, we have peer mediation classes in elementary schools. Young children appointed and trained as playground mediators, helping kids basically to sort out differences before they escalate to physical violence or some other altercation. And so there are 100 different ways that I could share with you to try and advance the concept of mediation in the broadest context. I'm going to a seminar in Rome, I hope, in December, where the conversation is about how to bring mediation skills to Syrian refugees in Western Europe. And there's already an app that's being developed for people's phones because that's about all these refugees own of any real consequence besides the clothes on their back. How can they access justice? How can they access resolution of problems? So can people put together an app on a cell phone that refugees, regardless of where they are in flight, can access to try and get access to some measure of justice? Just as another example of things, of conversations that are taking place out there in the world beyond the simple community of lawyering. And when I go in April to the International Academy of Mediators in Scotland, the whole conversation for 3 days is going to be about just this. Taking mediation skills and introducing them into a different environment. I'll give you one more example, and then I'll offer the question to somebody else. In the United States, there is a nonprofit organization whose sole job is to convene respectful conversations around large, divisive social issues. And so they will take an issue, healthcare, gun control, health and education, broad social issues, and they will spend months identifying hundreds of stakeholders, people who have a legitimate interest in how those issues should be resolved, and without whom the output of that conversation would be meaningless. And they identify those stakeholders and they start to bring them together. And they bring them together for weekend retreats. And pretty soon you have people who could not even envision ever being in the same room together coming to agreement on certain issues. The New York Times did a fabulous piece this summer on just one of those conclaves around healthcare issues, where people came together and forged agreement around a number of very contentious issues, all because of this effort to humanize each other and to have a rational, respectful, civil discourse around those issues. Long-winded answer, but expand your thinking whenever possible, because that will help reshape a broader community. I somewhat joke in the United States that we will know we will have arrived when somebody gets rear-ended by an automobile collision or aggrieved in some fashion, and the first words that come out of their mouth are, "I'm going to my mediator. Where's my mediator?" Right? Instead of the obvious, "I'm going to my lawyer." Right? Again, there'll always be room for lawyers, but it's a change in thinking that we need as a society when we've got 100 million lawsuits in one country, or 60 million in India, or Syrians who have no access to justice. We need to think as broadly as possible. And as lawyers, our mission is to really deliver the best of the legal services to this broader community. And so mediation, if you take nothing else away from tonight's comments, is a valuable tool to be able to offer your clients that does meet their needs in a way that other processes don't. Okay? All right. Other questions? Sir.
Boa noite, Dr. Bruce. Imagino que o senhor saiba que a legislação brasileira passou a aplicar a lei de mediação e incluiu no novo Código de Processo Civil há pouco mais de um ano que nós aplicamos essa legislação. E algumas particularidades ainda nos causam dúvidas. Uma delas é em relação à possibilidade do advogado sozinho participar da mediação. O nosso novo Código de Processo Civil prevê no artigo 334, parágrafo 10º, a possibilidade do advogado sozinho, sem o cliente, fazer a sessão de mediação com uma procuração específica. Isso é feito nos Estados Unidos? O que o senhor acha disso?
A longer conversation, and one that we will address on Thursday to some degree when we talk about mediation laws and statutes around the world in the context of training and certification. There's a saying in the United States, perhaps elsewhere, that no one is safe when the legislature is in session. Okay? What that means is there's always a risk when people are making laws about things of which they know something, but not a lot. Okay? And so I see mediation laws well-intended around the world, and yet most of them miss certain key aspects of the process. In Turkey, for example, a mediation law happened about 4 years ago. Interestingly, they've mandated that only attorneys can be mediators. Okay, good for the legal profession, but you can assume there's a whole swath of other people out there who had already been mediating who were somewhat disenchanted with that particular provision in the law. To your point, I fundamentally believe that attorneys should be in the mediation process representing their clients' interests. And in my experience, I would say in 6,000 mediations, less than 5% of the time am I meeting with clients alone without their lawyers, and only then with the lawyer's permission. Sometimes their blessing. Have at my client. If you can persuade them, Godspeed, but I can't do anything more. That kind of moment. And they'll walk out of the room and I'll start talking with the client. But that's far different than saying the lawyer does not have a role in that process. And so I'm very cautious about these legislative efforts to try and advance the cause of mediation where they might get it wrong to some degree. In California, where I live, right now there is a mediation law that protects confidentiality. And because of a narrow exception in the litigation involving lawyer malpractice where the mediation, the cloak of confidentiality prevented somebody in a subsequent lawsuit from getting information that happened in the mediation. The legislature is considering stripping confidentiality from the mediation process. I mean, what's more fundamental to our ability to conduct conversations in private session with parties than our pledge that what is said here remains here, confidentiality. And if a statute were to be amended to say mediation is no longer confidential, imagine how you and I would be communicating if you had to worry that I might tell somebody what we talked about, right? So those are the kind of missteps that sometimes happen. My hope is, in all legislative processes, that as well-intended as a legislative might be, that needs to be massaged and refined over time to deal with the real-life consequences of your culture and your legal community. Again, I want to be cautious because I don't know the law nearly like you do, and I don't know the culture at all. But I would be concerned if a process was being perpetuated by a statute that didn't allow the appropriate involvement of lawyers and, in fact, excluded them from parts of the process, just as a matter of principle. Did that answer your question? Okay, thank you.
Okay.
Hopefully I'm not stepping on any legislature's toes tonight.
Alguma outra pergunta?
Bem, eu não sou advogada, também não sou mediadora, não passei por nenhum treinamento, sou uma mera estudante de direito ainda. Então, eu queria pedir para o senhor se eu poderia recomendar alguns autores que podem embasar essa prática, que tem contribuído ao longo desses últimos anos para embasar essa prática na mediação.
Another good question. One of the challenges of being a nascent or developing community is that it takes a while for the publications to sort of catch up. Okay? And it's not just publications. I didn't mention this earlier, but what I've done in the last 5 years besides teach and mediate is I've developed an online mediation curriculum called Edwards Mediation Academy, where we deliver mediation training online to those people that can't access in a face-to-face environment. So for those cultures in distant parts of the world that will never come to a Harvard program on negotiation or can't afford to bring, trained mediators to speak, there's other options available. So they're not necessarily all publications. But that said, there's very few sort of textbooks on mediation, if you will. Chris Moore, who is a mediator mentor of mine, wrote a book called The Mediation Process. And I think he's got 12 or 14 stages of mediation that he examines from a sort of quasi-academic perspective. What I find is that there are easier reads in what I'll call more popular publications that give you just as much insight into things like communication. There's fabulous books that are written on gender differences in communication. Sheila Heen from the Harvard Program on Negotiation wrote a great book on how to have difficult conversations being the topic of the title of the book. I will read things like, we had a former Attorney General, a former Secretary of State in the United States, Bill Richardson, and who negotiated with heads of states from Fidel Castro to lots of other world leaders. And he talks about the things that helped him perpetuate conversations, build connections, and get beyond difficult moments of impasse in a real layman's sense of things. So there's lots of those kinds of materials out there that will help you become a better communicator and understander of human behavior that I think are as valuable as simply reading a textbook on the stages of the mediation process. Okay?
Ok, se não houver mais pergunta, eu passo a palavra para Mariana para fazer. Ah, tem?
O senhor começou a palestra falando da nossa cultura, o que nós podemos trazer de bom para a mediação e aplicar na nossa cultura. E o senhor falou muitas vezes sobre a aplicação da justiça, realização de justiça. Eu queria aproveitar essa oportunidade de ouro, porque a gente sabe, quando estuda a cultura americana, que o americano ele vive o direito, ele respira o direito à sociedade americana, pelo menos que a gente estuda na faculdade aqui no Brasil, o Rule of Law. Então, eu queria perguntar para o senhor como é a aplicação, a realização da justiça para o americano do Norte, principalmente na mediação. Obrigada.
That's the topic of another lecture, I think.
We have all night.
That's okay. I agree with you that as citizens of the United States, we have an almost obsession with rights and, at times, a litigation environment. People who are aggrieved in many contexts in their lives, as I said earlier, sometimes think, what will my lawyer say? You know, how do I find a lawyer to address this? To the point where sometimes when we're in mediation, you can't believe the kinds of things we deal with. One time I had a case involving a woman who her husband or fiance gave her a very expensive diamond engagement ring that was advertised to be flawless. And when she sent it for appraisal, it had a very theoretical but obscure flaw. And she sued since this is all being streamed, I won't use the names, but it comes in a very nice blue box. And she sued this company, and what proceeded was years of litigation over this affront that, I'll speak for myself, I probably wouldn't have considered to be worthy of that kind of litigation. And so in the United States, yes, we have this sort of almost crazy obsession, with litigation. But the mediation process, I hope I'm conveying tonight, transcends this sort of strange U.S. environment. When I was in Berlin last week, they're very receptive to mediation. They're using it in large construction cases and construction contracts, and their legal system is not nearly as contentious as ours. They have access to judges within 9 or 12 months if they want to get their cases to trial. Yet there's still reasons and benefits for this process to assist them, whether they're dealing with large construction projects or employment matters or business disputes or other kinds of claims that arise within their culture. So I did start this process by saying, as a first-time visitor to your country, I want to be very careful that I'm not sounding preaching up here, because Lord knows we have our own issues that we're wrestling with day in and day out, 6,000 miles away. But as it relates to mediation, it is a process that has transcended cultures. And there are those cultures that are very receptive. When I went to Rwanda earlier this year, after the genocide, the only way they could seek to rebuild their country was by creating courts of reconciliation and justice. And so it's really a matter of them translating that same cultural mindset now into civil litigation and adopting the best of mediation practices. And so now they're putting together a law to favor that. When I go to other cultures where maybe historically they'd almost rather kill each other than find agreement, you can bet that it's a harder sell, but perhaps even more important. So none of that stops us. It's really just a question of trying to help you find the right entry points, find the right blend of these attributes with your own systems. And that's why I encourage you all to use this as a bit of a catalyst for conversation, right? All I'm really trying to do is spark the debate and the conversation going forward. But at the same time, I'm trying to give you a sense that commercial success of mediation is possible. And believe me, when I started this 30 years ago, I probably ran into many of those same conversations, those same roadblocks that you did in your own community or have in your own community. But with time, they can be overcome. And this goes back to your question, which was, as you think about expanding mediation beyond simply the legal culture and lawyers, take the long-term view. I was privileged enough to be, and still am, one of the youngest partners of 100 within my company. Yet I've been there since 25 years. We merged our company with this one. So I've been fortunate and able to take the long-term view. If we can change our 250-year culture in 25 years or less, you can do it too. But it will take a certain amount of fortitude, a certain amount of persistence, just as you do day in and day out in your mediation role.
Boa noite a todos. Primeiramente, gostaria de parabenizar pela brilhante palestra, rica e esclarecedora do Dr. Bruce. E também agradecer ao CBMA e ao IAB pela rara oportunidade que está proporcionada a todos nós de assistirmos relato tão esclarecedor. Uma curiosidade que eu tenho com relação ao modelo norte-americano reside na seguinte pergunta. Aqui no Brasil, eu gostaria de saber se existe também no modelo norte-americano a figura do mediador judicial. O modelo brasileiro prevê a mediação privada e, ao lado da mediação privada, a mediação judicial, por determinação da lei e por regulamento próprio por intermédio do CNJ. Eu gostaria de saber se esse modelo também norte-americano abriga essas duas figuras ou exclusivamente a mediação privada. É só isso. Muito obrigado.
Thank you for your kind comments. I am very careful and should be even more careful about using labels like the American model, because every time we attempt to generalize, I can think of all the exceptions. And in the United States, there are a variety of models where mediation is applied. Certainly, we've got a whole community of community mediators that operate traditionally outside of the formal legal environment and handle a variety of broad-based community issues. In the commercial setting, we have a mix of private mediators, and those could include retired judges. They do include people like myself, former lawyers. They do include psychologists and university professors, and sometimes substantive specialists like engineers or certified public accountants, depending on the substance of the dispute. So be careful about overgeneralizing. Private mediators then can also operate in different contexts. You can work with a large organization like mine, JAMS. You can work in smaller conjunction with other mediators sharing office space. People work as individual mediators off their kitchen table. So there's a lot of different business models out there. I would still say that there are, somebody's asked me this question, and I'd really have to think about whether or not there's a predominance of retired judges in the commercial mediation community. I'll be interested in your answer on this, Vic, over dinner. I still think it's probably more weighted in terms of attorney mediators than retired judges. But as you can tell from my answer, there's a lot of retired judges in this community. And people will work in the community, the private mediation setting, or many people will mediate in court-annexed programs where the courts have supplied the training and the mediators volunteer their time, at least partially. We'll have, this might be applicable in your community someday, where mediators come in a court-annexed environment, offer their mediation services for a portion of a day or a number of hours, and then are free to begin charging the participants if mediation extends longer, or if it goes back to their office on a different day. So there's different models, but community mediators, commercial mediators, private mediators, we work in a variety of different settings and under different business models. Does that answer your question? Somewhat? Okay. Yes, different models. So I try and be careful about the American model because we have a lot of diversity within our country, as you can appreciate. Yeah.
Mais alguma pergunta? Então, eu vou dar a palavra a Mariana, que certamente tem alguma indagação a fazer.
Eu vou fazer uma última pergunta, porque não é todo dia que temos um mediador com 30 anos de experiência falando para nós. Então, queria te perguntar duas coisas. Primeiro, pela sua experiência, quais seriam os do's and don'ts, né? O que você acha que os advogados devem e não devem fazer numa mediação, numa sessão de mediação ou numa pré-mediação, em relação aos clientes, em relação ao trabalho do mediador? E a segunda coisa, aí também aproveitando a sua experiência, se você consegue lembrar ou se tenha te marcado algum caso em que você, na sua percepção, o advogado tenha feito a diferença para que aquela mediação tenha tido sucesso e para aquela mediação não tenha tido sucesso. Ou seja, que a interferência do advogado fez a diferença para o bem ou para o mal.
Let me see if I can remember your questions. The attorney's role first. Prior to the mediation process, the best things that attorneys, mediation advocates, attorneys can do with their clients is help adjust their expectations. So often as lawyers, I've found many lawyers like to tell their clients what they want to hear rather than what the real world might offer them as they go forward. And so helping to soften your client's expectations is certainly chief amongst the things that I would counsel effective advocates to do and that the best ones do well. I think it's helpful to explain to your client the difference in the role that they will see you take in mediation versus the role they might expect you to take in the courtroom. So I think it's very helpful to say, while in the courtroom you can expect me to be a pit bull on steroids, in mediation I'm going to adopt a different tone. And to some degree, I'm going to look for moments of conciliation and opportunities to resolve this dispute for you. But that's the difference between the processes. So kick me under the table or talk to me privately if you think I'm going too far in that direction. But understand, these are two very different roles, and I want you to know that I'm equally committed to your interests, regardless of how I'm approaching the task. Okay? In the mediation process itself, I know this is going to sound a little bit trite or obvious, but I think the best thing that lawyers can do is something that we're not really trained to do. See where I'm going on this? Listening, right? I mean, everybody had classes, I assume, in Brazil, growing up in school in reading, writing, listening, not so much, right? Certainly not in the United States. No, we never took a course in listening. And as lawyers, never trained as a listener. So have to be self-taught. So being open and aware to a different perspective. I often tell people from the mediator's side of the table, the same mindset that brought you here today is not going to be the mindset that you'll have to take to exit this room successfully. Meaning what? You've got to be open-minded. And you can only be open-minded if you listen for those things that are going to cause you and your client to view this set of facts differently. So those are some of the things, believe me, there are others, but those are some of the things that the best advocates can do effectively to try and advance their clients' interests. The second part of your question, Mariana, had to do with lawyers doing things well that achieved their successful outcome and those things that maybe didn't.
Yeah, or one specific case that you can recall when a lawyer made a difference in the negotiation, either to settle the case or for the mediation to be a disaster.
So, I'm human. I have an ego. I try and keep my ego in check at all times. Being a mediator is challenging because you've got to have a sufficient ego to come into a room, sometimes with this many parties and as many interests at stake, and to be able to tackle that problem, direct traffic, manage the conversations, and move conversations forward productively. Yet at the same time, you have to have an absence of ego. You have to be able to realize that this is the party's dispute, that yes, you've got a gentle hand on the tiller, but the wind that's coming is really coming from the parties. And so I say that because most of the cases that settle, I hope, settle because of the lawyer's involvement. Those that settle with less bloodshed means the lawyers are generally better at their jobs. Obviously, there are days where I like to think that I've helped that process, sometimes even broken the impasse or otherwise managed to get them back on course. But 30 years is kind of replete with examples of lawyers managing the moment in very real ways, starting from the very beginning. I told you one example earlier, again, a Fortune 500 company where the representative from the lawyer from the company stood up and said, before we even begin, I know that there are issues that are going to separate us today, some very serious issues. My lawyer will talk about those. But I know that there's nothing more personal in this lifetime of ours than our children. And there's nothing more painful to a parent than having your child injured. And I want to acknowledge that I have children, and I'm not here lightly because you have a child who's been injured. I'm here because I want to try and help resolve this case. And he sat down, and the case started. But it started with a completely different tone in conversation because this lawyer knew how to help set the right tone. Examples of impasse moments where lawyers have said, I don't know what to do. I am going to take a walk with the other lawyer. Bruce, I don't want you to come. This is just the two of us. And the two of them will take a long walk. And they'll come back and they'll say, while we're not in agreement, I think we can at least continue moving forward with the conversation. We've aired some differences between us. I think that that was a productive conversation. Let's keep going. So I'm always looking to lawyers. It's really one of the dark secrets of mediation to share with you. I never know as much as the lawyers in the case. Okay, don't tell them that. I do read their materials. But I always look to the lawyers in the room as people that are more intelligent than I am about what their clients' needs are, and I'm continuously looking to them for guidance. The best mediation advocates become champions of the process. They know how to approach me, when to give me guidance, when to subtly direct me away from being on the wrong path. And I view the mediation process as molding in soft clay. And sometimes that soft clay starts to take shape over time to where it actually resembles something. Other times, you got to throw it away and start again. But I'm open to that as the mediator, and the good lawyers are going to help me in that job. Okay? In terms of lawyers behaving badly, I mean, that's a whole nother night. Because from the beginning of the process where lawyers in a pre-mediation context, in a conference call, will begin to argue their position, and I will have to sort of gently back them away to suggest there'll be times where I want to hear what you have to say about the case, but this isn't that moment, where they're at risk of alienating people or keeping people from even having a baseline agreement to come to mediation because of their behavior or their excessive advocacy. There are times in mediation where lawyers do any number of things that are disruptive to the process, some because it's a misguided strategy that they're seeking to follow, sometimes because they simply they can't help themselves. And there are times where I will take lawyers aside and privately say to them, what's going on? Am I misreading the situation? Because it doesn't seem to me like you need to be quite as angry as you are with the other side. If that's accomplishing what you hope it's accomplishing, I'll stand back. But I just need to let you know I'm not seeing it that way. So I will coach people in this process is what I'm getting at. But it is not uncommon for lawyers to show behaviors that range from mildly uneducated in mediation to grossly non-productive and everything in between. And so as mediators, part of what we're trying to do is help them be better lawyers, help them be better selves in this process. If that answers your question.
Tudo bem. Bom, eu quero encerrar essa sessão, primeiro agradecendo muito ao professor Edwards, que nos deu uma magnífica lição do procedimento dos Estados Unidos e dizer que esse é um processo cultural que nós estamos ainda no início, porque as faculdades, elas ensinam ao litígio. Você nunca tem uma aula de negociação, de mediação, e, na realidade, o advogado brasileiro, quer dizer, ele, na sua estrutura formal, ou seja, aquilo que ele adquire na escola de direito, é no sentido de quais as regras que terá para seguir num processo de litígio. Quer dizer, a mediação, ela está positivada, ou seja, está legalizada há muito pouco tempo, embora a prática da mediação ela seja perfeitamente ligada à cultura brasileira. Nós temos a mediação sendo praticada no nosso dia a dia. Quer dizer, quando dois irmãos brigam, e em vez de procurar a mãe, procuram a tia para se aconselhar, na realidade eles estão fazendo um processo autêntico de mediação. Quer dizer, a cultura brasileira leva nesse sentido, mas não havia nenhuma regra específica que dissesse que isso deva ser apresentado como alternativa antes de se recorrer aos processos, os processos judiciais. No exemplo que você deu, que o dia que é de chegar, onde ao invés de I'm going to court, I'm going to my mediator, eu diria que talvez ele diga, eu vou para o meu advogado, e o meu advogado vai aconselhar a mediação ao invés de uma disputa. Quer dizer, esse é o processo que nós ainda estamos no estágio inicial do Brasil, de ter a consciência de que a briga judicial, ou qualquer tipo de briga, é uma coisa disruptiva com relação à harmonia social. Uma vez que em qualquer arbitragem ou qualquer processo judicial tem sempre um vencedor e um perdedor. E alguém sai ferido, muitas vezes havendo a possibilidade de arrumar uma solução que seja satisfatória para os dois. Eu digo que nesse momento de tanta dificuldade social, a mediação vem como um remédio muito adequado para resolver questões de uma natureza mais explosiva, porque a mediação permite o diálogo e compete ao advogado convencer o seu cliente a procurar a mediação ao invés de partir direto para a questão judicial. Quer dizer, o tema de hoje era o papel do advogado na mediação. Quer dizer, essa é a nossa realidade. Nós temos que nos acostumar a que, antes de procurar uma solução litigiosa em que ou o seu direito vai ser reconhecido ou não será reconhecido e alguém sairá ferido com isso, procurar uma situação em que se possa buscar harmonia. É isso que acontece na tradição do povo brasileiro, buscar uma harmonia, seja no amigo comum, seja na família, e que agora nós estamos no processo de levar isso à nossa cultura, também à cultura jurídica. Então, o que nós ouvimos hoje foi uma demonstração de que, como a prática americana tem muito a nos ensinar. É evidente que existe uma diferença de mentalidade muito grande entre os Estados Unidos e o Brasil nesse aspecto, no aspecto da necessidade da disputa, necessidade, muitas vezes, por deformação do advogado, o advogado procurar evitar aquela reação natural que é de procurar as cortes judiciais. Quer dizer, procurar um sistema alternativo de mediação onde ninguém sai ferido, onde a solução é harmonicamente desenhada e que, mais do que tudo, haja um exemplo para a comunidade. A grande dificuldade do processo judicial são justamente os precedentes. Os precedentes são aplicados a determinados fatos e são usados como referência em situações que os fatos são diferentes. Quer dizer, na mediação, os fatos vão ser expurgados na apresentação ao mediador. E o papel do advogado é de suma importância para fazer que essa beligerância inicial que ele é procurado através do seu cliente seja transformada na procura de uma solução harmônica. Então, o papel do advogado é relevantíssimo, é o mais importante, porque é ele que levará o seu cliente, convencer ao seu cliente de que uma solução harmônica pode ser mais interessante sobre todos os aspectos do que uma decisão proveniente de uma corte judicial. E, mais do que tudo, no nosso caso, muito mais rápida e efetiva do que a própria arbitragem. Nós temos o nosso problema das demoras judiciais, mas a arbitragem ela também tem o seu custo de tempo e muitas vezes o problema não é solucionado no seu momento real. Então, a mediação se apresenta como o remédio mais apropriado para que a harmonia seja estabelecida em qualquer situação de divergência. Professor Edwards, a sua palestra foi muito esclarecedora e, evidentemente, que esse Instituto deve estar aberto para mais discussões nesse sentido, porque temos muito a aprender com as práticas que foram bem desenvolvidas em outros países. Realmente foi uma noite muito importante para o IAB, para o CBMA, e é um avant-première do que teremos na próxima quinta e sexta-feira, quando discutiremos amplamente o que mais que devemos saber sobre mediação. Muito obrigado pela sua apresentação e somos-lhe muito gratos. Ok. Muito bem, foi uma sessão muito proveitosa e eu dou por encerrado. Professor?